Payback times.
The packet landed back across the glass table with the kind of deliberate softness that somehow screams louder than a shout. 2 fingers. Clifton Morrell used exactly 2 fingers to push my documentation back toward me. The way you'd return a menu at a restaurant that had disappointed you before you even opened it. Sir, with respect. He paused there, letting the phrase do its work. People who start sentences that way have already decided to be disrespectful. Homes like yours in neighborhoods like that don't appraise anywhere near what you're claiming. I've been doing this for 30 years. You're going to want to recalibrate your expectations before this gets embarrassing for everyone. I noticed 3 things in rapid succession. The way his cufflinks caught the winter light coming through the floor-to-ceiling windows, silver and expensive, the kind of detail meant to establish hierarchy before a single word is spoken, the word recalibrate, which I recognized as a trained de-escalation term lifted straight from adjuster language, designed to make claimants feel irrational rather than correct, and the phrase homes like yours in neighborhoods like that, which was doing so much work in so few words that I almost wanted to applaud the efficiency of it. Almost. I picked up the packet and smoothed the corner where his 2 fingers had bent the manila folder. Tucking it under my arm, I smiled at Clifton Merrill, Regional Claims Director of Hartwell Premier Insurance, a man who had just made the specific and costly mistake of assuming I was only what I looked like sitting across from him. A middle-aged black man in a well-worn sport coat, holding a claim he probably had no business filing. "Thank you for your time," I said. "I'll be in touch." I walked through the gleaming lobby past the waterfall feature that probably cost more than my grandmother's first mortgage. The door closed behind me with a pneumatic hiss, and I stood on the sidewalk for a moment, the documentation under my arm, the February wind cutting through my coat. I was not embarrassed. I was taking notes. The house had been in my family for 61 years. My grandmother, Celestine Abubakar, kept her name after she married, which in 1963 was not a small act of will. She was the first black woman to own property on the 2400 block of Hadfield Street. She used to tell me about the real estate agent who showed her the Victorian, this narrow, stubborn beauty with fish scale shingles and a wraparound porch that sagged slightly to the left. The agent had been nervous the whole walk-through, she said, kept glancing out the windows as if he expected someone to arrive and put a stop to things. She bought it anyway, paid cash for the down payment, money she had saved over 11 years of domestic work. Named the house Clara, after her own grandmother. I grew up in Clara. I learned to read on that porch. Summer mornings with the neighborhood sounds rising up around me. I left for college and came back. Left for my first real job and came back. Buried my grandmother in the yard she loved. Her specific request, and one that required more permits than I cared to think about, and came back again. When I left the insurance industry 8 years ago, after 22 years of watching what companies like Hartwell Premier did to people who trusted them, I came back to Clara, and I stayed. I refinished the floors, replaced the original radiators with something that actually worked, kept the fish scale shingles because some things you don't change. The storm that hit in January was the kind of cold that weather forecasters kept calling historic, which is just a polite way of saying that infrastructure in older neighborhoods wasn't built for it. The pipe that burst was in the wall between the kitchen and the dining room, a supply line that fed the upstairs bathroom. I was at work when it happened. By the time my neighbor Ruth Ann called me, water had been running into the walls for 3 hours. I came home to a kitchen ceiling, bowed and sagging with trapped water, hardwood floors already beginning to buckle, and a sound like steady rain coming from inside the walls. The smell was immediate, that particular combination of wet plaster and something older, deeper, the smell of a house trying to tell you something urgent. I documented everything before I touched a single thing. That's the adjuster in me, still running, even when I wish it wouldn't. I walked every room with my phone, narrating as I went, timestamp visible in the frame. I called a licensed plumber for emergency service and got their written report of the cause and the timeline. I called 3 independent contractors within the week and collected written estimates. By the time the licensed mold remediation specialist finished her assessment, I had documentation that would make a first-year paralegal comfortable presenting it. Total damage, $150,000, not a number I invented, a number that emerged from evidence. I filed the claim with Hartwell Premier on January 28th. Clifton Merrill called me 12 days later to schedule what he described as a collaborative review session. I should have recognized the language immediately. I taught it. My kitchen table has seen a lot of legal pads. It's where I prep for the cases I support at the Legal Aid Center, where I reconstruct claim files for clients who have been denied coverage they were owed, where I have spent more late evenings than I can count trying to find the language that will make an insurance company behave like what it's supposed to be. The light over the table is good. I installed it myself, an overhead fixture with a warm bulb, because fluorescent light makes everything look like evidence. Which is appropriate, I suppose, because tonight everything was evidence. I had my Hartwell Premier policy open on the left side of the table, my claim documentation in the center, my old training manuals from my adjuster days stacked on the right, the 3 I had kept when I left because they had been most instructive about the distance between what companies said and what they did, and a fresh legal pad in front of me, oriented vertically, uncapped pen at the ready. At the top of the pad, I wrote one word: documentation. Then I went back to the conversation. Clifton had said several things in that office that I had cataloged and stored while keeping my face pleasantly neutral. The comment about neighborhood market instability had been the obvious play, an attempt to plant doubt about valuation before I could anchor myself to the contractor estimates I had already submitted. Standard deflection. In my adjuster days, I would have given it a 4 out of 10, sloppy, because I had already submitted 3 independent estimates and a professional remediation assessment. You cannot argue market instability against licensed contractor quotes. They are not comparable data, but the comment about gray areas in my policy, that one I kept returning to. He had said it twice, not once. Twice. People do not accidentally repeat things in professional settings. Repetition is intentional. He wanted the phrase lodged somewhere in my thinking, some anxious backroom of my mind, where it might grow into hesitation. I found the relevant section in my policy in under 4 minutes. I know how these documents are organized because I spent years organizing them, years learning exactly where the exclusions lived and how they were worded to sound broader than they actually were. Section 14. Water damage. Standard coverage for sudden and accidental discharge of water from within a plumbing system. Then the exclusion language, which Clifton had gestured at without quoting. Damage caused by continuous or repeated seepage or leakage of water over a period of time. Gradual water damage. That was the exclusion he was implying, applied to my claim. I sat with that for a moment, the heat from my teacup warming my hands, the house quiet around me, in the way old houses get quiet on winter nights. Not silent exactly, but settled, like it was listening too. Here is what Clifton Merrill knew, or should have known, because it was in the documentation I submitted. The pipe burst during a documented storm event, during a 48-hour period in which temperatures dropped to 11 degrees Fahrenheit, and the city issued a weather emergency. The plumber's written report was unambiguous. Sudden failure of a supply line due to freeze-related pressure. The damage that followed was the result of that sudden event. Gradual water damage exclusions exist for situations like a slow leak under a sink that a homeowner ignores for 6 months, a dripping pipe in a basement that gradually rots the subflooring over years, damage that a reasonable person could have detected and mitigated. The distinction is not subtle. It is the entire legal spine of the exclusion. My claim did not come within a country mile of that exclusion. Clifton Morrell knew this. I was certain of it. Because to have gotten to regional claims director at a company like Hartwell Premier, you had to be able to read a policy. You had to understand the exclusions, their purposes, their limits. You did not accidentally misrepresent coverage language at his level. You did it on purpose, and you did it because 29 out of 30 claimants would go home uncertain, might even accept a reduced settlement rather than fight language they did not fully understand. I thought about the training sessions I had sat in. Early in my career, when I was still young enough to believe that the technical complexity of insurance was incidental rather than strategic. A senior claims manager, I can still see his face, ruddy and cheerful. The kind of man who coached Little League, had stood at a whiteboard and explained the value of what he called soft uncertainty. You do not deny a claim outright in the early stages, he had explained. You introduce questions. You use language like gray areas and policy limitations. And let's make sure we're all looking at the same thing here. You let the claimant do the work of undermining their own confidence. It had taken me years to understand what I was being taught, and more years after that to be honest with myself about what I had participated in. I am being honest now. What Clifton did in that office, implying a gradual damage exclusion applied to sudden storm damage, using the phrase gray areas to create manufactured uncertainty about an airtight claim, has a legal name. It is called misrepresentation of policy provisions, and it is one of the foundational acts of insurance, bad faith. Bad faith. The phrase sounds abstract until you understand what it actually means in practice. An insurance company operates under what the law calls a duty of good faith and fair dealing. It is not just a courtesy. It is a legal obligation baked into the contract you sign when you accept coverage. When an insurer knowingly misrepresents what a policy covers, when it invents exclusions or implies them where they do not exist, when it tries to pressure a claimant into accepting less than a reasonable person would believe they are owed, that is bad faith. Not aggressive claims negotiating, not a hard stance, bad faith. And it opens the door to remedies that go beyond the original claim value, up to and including punitive damages in states that take it seriously. I know this because I eventually left the room where the training sessions happened. I know this because I spent 8 years helping people who were on the other side of the table I used to sit at. I know this because I have sat across from elderly homeowners who were told their flood damage was a drainage issue and their drainage issue was not covered, because I have helped reconstruct the files of people who accepted 30 cents on the dollar because a man in a good suit used the right kind of soft language and they went home uncertain. I added a second line to the legal pad: misrepresentation of policy provisions. Gradual damage exclusion does not apply. Sudden storm event documented. Then a third: good faith and fair dealing. Duty exists as matter of law, not policy language. Research, state statute. My tea had gone cold. I got up to warm it, walking through Clara in the winter dark. And I thought about my grandmother navigating a real estate transaction in 1963 with a nervous agent and a city that had spent considerable effort making clear that people like her were not supposed to accumulate the kind of stability that property represents. She did it anyway. She did it with cash and documentation and the particular composure of someone who has already decided that the discomfort of others is not her emergency. I come by it honestly. Back at the table, I opened my claim file again. The full physical file I kept, not the digital copy, because physical files have a weight to them that I have always found clarifying. I reviewed the timeline I had constructed. Damage occurs January 19th. Claim filed January 28th. Meeting with Clifton, February 9th. At the very bottom of the file, beneath the contractor estimates and the mold report and the plumber's assessment, was a document I had requested under my state's claims handling regulations. Insurance companies are required, upon request, to provide the claim file documentation relevant to coverage decisions. Hartwell Premier's compliance team had sent it over without, I suspect, fully thinking through what it contained. It was an internal recommendation form. Standard format, I recognized it immediately, had filled out hundreds of them in my career. Claim number, policy number, claimant name, summary of damage, coverage recommendation. The recommendation was denial, insufficient coverage basis. The date on the form was February 6th. I had sat in Clifton Merrill's office on February 9th. They had recommended denial 3 days before our meeting. 3 days before Clifton reviewed a single piece of my documentation with me. 3 days before he gestured at gray areas and talked about neighborhood market instability. 3 days before he slid my packet back across the table with 2 fingers, as if it was not worth his full hand. The meeting had never been a review. It had been a performance. A carefully staged opportunity to introduce doubt, to make me feel uncertain about a claim they had already decided to deny, and to create a record of having met with me, of having given me the courtesy of a face-to-face conversation before the formal denial letter arrived. I set the form down on the table. Outside, a bus went by on Hadfield Street, its lights moving across the kitchen ceiling. The radiator ticked. Somewhere above me, in the walls that were still drying out, Clara settled slightly on her foundation, the way she always did on cold nights. I picked up my pen. The denial recommendation form went into a new section of the legal pad, dated 3 days prior to meeting, I wrote. No documentation review had yet occurred. Meeting conducted after coverage decision already made. This was not aggressive claims management. This was not a hard line on a borderline case. This was a company that had decided to deny a $150,000 claim before reading a word of the evidence, then staged a meeting designed to manufacture the appearance of due diligence while introducing just enough manufactured uncertainty to make the claimant doubt himself. I knew exactly what kind of play I was in, and I knew exactly what my next move was. The certified mail arrived on a Tuesday, which felt right. Tuesdays have always struck me as the most bureaucratic day of the week. No drama of a Monday, no momentum of a Wednesday, just paperwork and patience. I signed for the envelope at my front door, still in my reading glasses, coffee cup in my other hand, and brought it to the kitchen table where the legal pad waited. Hartwell Premier's claims file on my property ran to 63 pages. I know because I counted, the way I always count, laying each page face down in a neat stack to the left as I worked through it. My written request had cited the specific state regulatory provision that entitled me to the complete file, all internal communications, all documentation, all notes. The compliance team had complied, again, without fully thinking through what they were sending. The email was on page 41. It was from Clifton Merrill to his supervisor, a woman named Diane Troop, whose title was listed as Vice President of Regional Claims. The subject line read, Abu Bakr Reyes, 2416 Hadfield Street. The date was February 5th, 1 day before the formal denial recommendation, 4 days before our meeting. I read it twice, then a third time. The relevant passage sat there in flat corporate language. This one is a nuisance file from a deteriorating zip code. Recommend denial at first review. Claimant has submitted documentation, but property value doesn't support claim magnitude. Suggest we move quickly before he lawyers up. I set the page down carefully on the table, smoothed it flat with my palm, and picked up my phone. I photographed the email from 3 angles, making sure the date and Clifton's name and Diane Troop's name were all legible in every frame. Then I opened my encrypted cloud storage app and uploaded all 3 photographs. Then I went back through the entire 63 pages and photographed every document that contained a date, a name, a coverage decision, or a notation about my property. 22 images in total. I did this before I let myself feel anything. Old habit. You secure the evidence before you react to it because reaction clouds, judgment and clouds cost you. Then I sat down with my coffee, which had gone cold again, and I let the implications settle over me like dust, nuisance file, deteriorating zip code, before he lawyers up. Clifton Merrill had looked across a glass table at me and talked about recalibrating my expectations, and the whole time he already knew. He'd already written this email. He'd already signed off on the denial recommendation. The meeting had been exactly what I suspected: theater, stagecraft, a professional courtesy, extended solely to manufacture a paper trail that would make the denial look considered and deliberate, rather than what it actually was, predetermined and rooted in assumptions about where I lived and what that meant about my claim. My grandmother bought this house with 11 years of savings and a composure that must have cost her something I will never fully understand. She walked through it with a nervous real estate agent, and she bought it anyway, and she named it Clara, and she stayed for 40 years. Now, 61 years later, a man in silver cufflinks was calling it a nuisance file in a deteriorating zip code. I picked up my phone and called Priya Nandakumar. I'd known Priya for 4 years, since she'd co-presented a workshop at the Legal Aid Center on insurance bad faith litigation. She was 38, second-generation Indian American, had gone to law school specifically because her parents' small business had been destroyed by a bad faith denial that they never recovered from. She was the kind of attorney who wore courtroom-appropriate blazers to coffee meetings and asked questions with the focused patience of someone who is already 3 steps ahead of your answer. She picked up on the second ring. "Desmond, tell me you have something good." "I have something that is going to make you want to cancel your afternoon," I said. She was at my kitchen table by noon. She read the email without speaking, read it again. Then she set it down, took her glasses off, and said simply, "He wrote before he lawyers up in an internal company email." Page 41. Clifton Morrell has been doing this for 30 years, and he wrote before he lawyers up in an internal company email. "People get comfortable," I said. "When you deny enough claims without consequence, you stop thinking about what the file looks like from the outside." She put her glasses back on, and her expression shifted into something harder. "Desmond, you understand what this is?" "I do. This is not a contract dispute anymore. This is a statutory bad faith claim. The predated denial alone gets us there. They made a coverage determination before reviewing your documentation, which is a textbook violation of prompt claims handling requirements. But this email," she tapped the page with one finger, "this is evidence of intent. This is someone deciding to deny your claim because of where you live and what they assumed about you, and then documenting that decision in writing. What's our exposure on damages?" She smiled, and it was the specific smile of someone who has been waiting to answer that question. Under the Unfair Claims Settlement Practices Act, if we establish bad faith, you're entitled to the full policy benefit, $150,000, plus consequential damages for losses you incurred as a result of the denial, plus attorney's fees. She paused. "And depending on how the court views the willfulness of it, punitive damages. I want to proceed." "I was hoping you'd say that." She pulled a legal pad from her bag. "Here's what we're doing, and in what order. First, I need you to connect me with the best public adjuster you know. I want an independent assessment of that damage that has nothing to do with Hartwell's numbers." "Marcus Fells," I said immediately. "He's thorough. Former structural engineer before he got his adjuster's license. He'll treat all your notes like a personal insult if they're not complete." She wrote the name down. "Good. Second, I want a formal property appraisal, current market value, done by a licensed real estate appraiser who can hold up under cross-examination. Whatever Clifton implied about the neighborhood in that meeting, I want a number that ends the conversation." "I know a real estate attorney who does appraisals." She's done 3 expert witness appearances in the last 2 years. Even better. More notes. Third, I'm filing a complaint with the State Department of Insurance. Today, if possible. I'm going to cite the predated denial, the misrepresented exclusion, and this email as evidence of systemic bad faith. Once the Commissioner's office opens a review, Hartwell is no longer just managing your claim. They're managing a regulatory investigation. That changes their calculus. It changes everything about their calculus. She looked up from the pad. Are you prepared for this to get uncomfortable before it gets better? They're going to push back before they fold. I thought about Clifton's cufflinks catching the light, the 2 fingers, the word recalibrate. I've been preparing for this for 22 years, I said. Marcus Fells arrived at the house on a Thursday with a duffel bag full of equipment, a camera with a lens that could probably read a serial number from across the room, and the energy of a man who takes genuine offense at sloppy damage assessments. He was in his early 50s, built like someone who still played recreational basketball, with the systematic thoroughness of an engineer who'd never fully stopped being an engineer. He spent 4 hours in the house. I stayed out of his way mostly, except when he asked me to point out the original plumbing layout or show him where I'd found the first signs of water. He pressed on walls, checked subfloor deflection in 3 rooms, got into the crawl space with a moisture meter and a flashlight, and didn't emerge for 40 minutes. He was silent in the focused way of professionals who don't narrate their work. When he came back upstairs, he sat at my kitchen table, becoming, in that moment, the 3rd person in 2 weeks to use it as a workspace, and opened his laptop. You submitted $150,000, he said. That's what the 3 contractors came back with. He nodded slowly, the way people do when they're being diplomatic. I'm going to come in at $162,000. Your contractors assessed the visible damage thoroughly. What they didn't fully account for is the secondary structural impact. There's moisture infiltration in the exterior wall, framing between the 1st and the 2nd floor, that's going to need remediation before you can close the walls. And the hardwood in the dining room has enough subfloor damage underneath it that you're looking at a full replacement, not a refinish. I processed that. You're coming in higher than my claim. I'm coming in at what it actually costs to fix it correctly. He turned his laptop toward me, a preliminary breakdown already formatted on the screen. When I write this report, it is 47 pages. I document everything with photographs, measurements, and material cost references. If Hartwell wants to challenge any line item, they will need an engineer to do it, and that engineer will agree with me, because the damage is what the damage is. How long until the report is final? 72 hours. I liked Marcus Fells very much. The real estate appraisal came back 5 days later, and it landed on the table like a quiet piece of artillery. Elena Vasquez, the real estate attorney Priya had vetted, had done her work with the same systematic seriousness as Marcus. Comparable sales in a 6-block radius, historical property records, current market conditions, in a neighborhood that had been rapidly gentrifying for 4 years running. The Victorians on Hatfield Street, she noted. In her executive summary, had appreciated an average of 31% over the preceding 3 years as renovation and investment accelerated. Clara's current fair market value, $480,000, nearly $500,000. Roughly double what Clifton had implied with his comments about neighborhood market instability and homes like mine. I assembled the dossier on a Saturday afternoon. Marcus's report on the left, Elena's appraisal in the center, Priya's legal filings, the Department of Insurance complaint, and the reservation of rights letter she'd sent to Hartwell, citing chapter and verse of the Unfair Claims Settlement Practices Act, on the right. Clifton's email, the predated denial recommendation, and my original claim documentation behind a divider tab in the back. I had gone into that meeting on February 9th with documentation that would have been more than sufficient for any good faith insurer. I now had documentation that was going to be sufficient for a jury. The formal denial letter arrived by certified mail on a gray Wednesday afternoon. I read it standing at the mailbox in my coat because I already knew what it was going to say, and I wanted to be done with the reading before I brought it into the house. Clifton cited Section 14 of my policy, the gradual water damage exclusion, the exact provision I had already established in writing with my own documented notes, and Priya's statutory analysis had no application to my claim. He wrote it with the smooth confidence of a man who expected the recipient to read the words exclusion and denial and stop there, to feel the weight of official language and retreat. He did not know who he was writing to. 3 days later, a FedEx envelope arrived. Inside was a check for $22,500 made out to me, paperclipped to a letter on Hartwell Premier letterhead. The letter described the payment as a good faith partial settlement representing Hartwell's assessment of covered damage under applicable policy provisions. The language was warm, almost collegial. Clifton wanted me to feel like I'd won something. Like this was the resolution after a difficult process. Like I should feel grateful. I almost missed the release on page 3. Almost. It was formatted to look like a standard acknowledgement form, the kind of administrative paperwork that accompanies any insurance payment. 3 paragraphs of dense language that, if you were not reading carefully, read like routine processing documentation. If you were reading carefully, you saw that signing and returning the form, or, in some jurisdictions, simply endorsing and cashing the check, constituted full and final release of all claims arising from the January 19th incident, including any claims of bad faith, statutory violations, or consequential damages. $22,500 to release a $150,000 claim, a $162,000 independent damage assessment, potential punitive damages, attorney's fees, and a statutory bad faith lawsuit. I photographed the check, photographed the letter, photographed all 3 pages of the release, including page 3, making sure every line of the waiver language was clear in the frame, sent everything to Priya in a single message with the text, page 3, don't let me cash this. She called me 8 minutes later. He actually sent a release in a FedEx envelope. She said, I want you to know that I have seen some things in bad faith litigation, Desmond, but the sheer audacity of this move. What's our response? We decline, in writing, and we're explicit that we are not executing the release, and that our position on the full claim value remains unchanged. Short, professional, nothing argumentative. We're not tipping our hand on the lawsuit yet. She paused. And you are absolutely certain you haven't cashed it. Priya, I know, I had to ask. I have clients, good people, smart people, who cashed the check because the mortgage was due and they needed something to hold on to. That's what he's counting on. That's why the number is $22,500 and not $8,000. It's high enough to feel like relief, low enough to be a fraction of what you're owed. I looked at the check on the table in front of me. $22,500. My grandmother's mortgage payment had been $214 a month. This number would have seemed incomprehensible to her, and even then, it would have been an insult. Walk me through the mechanism, I said, for the story, in case I ever need to explain exactly what he was doing here. She was quiet for a moment, the particular quiet of someone shifting into the register they use when precision matters. The $22,500 check is what's called an inadequate settlement, offer designed to induce waiver. It's one of the clearest signs of unfair claims practices. The insurer makes an offer that is facially reasonable to someone without legal knowledge. It sounds like real money, but which is designed to terminate the claimant's rights, rather than resolve the claim. The release on page 3 is the mechanism, but even without the release, accepting a partial payment and cashing a check can complicate your position depending on state law, because Clifton's camp will argue you agreed to the settlement. So the check is a trap. The check is a trap, and the release buried on page 3 is the door locking behind you. I heard her moving papers. Here's the full picture, Desmond, so you have it in your own mind, what Clifton has now done. On paper, is misrepresent a policy provision to deny a valid claim, fail to provide a reasonable written explanation for the denial. His citation of the gradual damage. Exclusion is facially inapplicable, and he knows it. Make an inadequate settlement, offer structure to induce waiver of additional rights. And throughout all of it, he's employed delay tactics. The staged meeting, the slow walked file, the check arriving weeks after the formal denial, to pressure you into accepting a number driven by desperation rather than actual claim value. Those are the 4 signs. Those are the 4 signs, and the steps to contest them, which you've already begun. You've compiled documentation, engaged a public adjuster for independent assessment, filed a regulatory complaint, and now we're at the stage of civil litigation under the Unfair Claims Settlement Practices Act. She let that sit for a moment. You've done everything right. You've done it in the right order. And because you spent 22 years on the other side of this desk, you didn't miss a single move he made. He counted on people not knowing what he was doing. Almost everyone he does this to doesn't know what he's doing. That's not a coincidence. That's the model. I wrote the short reply to Clifton's letter that night. Priya reviewed it and called it perfect. 8 sentences, professional, specific. We decline to execute the release. Our position on the claim value remains unchanged. We note that your written denial cites a policy provision, the gradual water damage exclusion, that is inapplicable to a sudden pipe failure during a documented storm event. We have retained independent counsel and will be in contact regarding next steps. Polite, unambiguous, and the phrase independent counsel, I knew from experience, would land in Clifton's reading of it like a stone dropping into still water. 2 weeks later, I submitted a formal request for mediation under the state's pre-litigation dispute resolution statute. The request named Hartwell Premier Insurance as the responding party cited the specific statutory provision requiring mediation before civil proceedings in insurance disputes and was copied to the Department of Insurance's Claims Oversight Division. When Priya called me to confirm Hartwell had agreed to the mediation date, I could hear something warm in her voice that wasn't quite there in our usual working conversations. Clifton responded through their corporate counsel, she said. Very controlled, professional. They agreed to March 14th. How did he sound? I didn't speak to him directly. It was through the attorney. But the letter was... She paused, seeming to choose words. It was the communication of someone who thinks he knows where this ends. Like he's already seen this movie, and he knows the third act. He thinks we're going to come to the table, argue about the exclusion, and eventually agree to something in the $60,000 to $75,000 range. He thinks we're here for a higher settlement number. That is absolutely what he thinks. What does he not know? She was quiet for a moment in a way that was deeply satisfying. He doesn't know that the Department of Insurance has opened a formal investigation into Hartwell Premier's claims handling practices in your zip code, triggered by your complaint, and that 2 of your neighbors have filed additional complaints as part of the same review. He doesn't know that Marcus's $162,000 damage assessment and the Elena's $480,000 appraisal exist. He doesn't know that the civil lawsuit, which names him personally as a defendant, by the way, is already drafted and will be filed in state court the morning of the mediation, making it public record before he sits down at the table. Another pause. And he does not know that his own email, the one calling your property a nuisance file in a deteriorating zip code, is going to be Exhibit A in federal discovery if this goes further. He told me to recalibrate my expectations. He did. I think we're both going to find out what that phrase actually means, I said. I hung up and stood at the kitchen window, looking out at the side yard where Clara's original garden had been, where my grandmother had grown tomatoes and roses with the particular determination of someone who was going to make things grow, whether the neighborhood wanted her to or not. The evening light was the particular gold of late winter, giving way to something warmer. In 3 weeks, I would walk into a mediation room, and Clifton Merrill would sit across a table from me for the second time. He would be expecting a negotiation. He would be receiving a reckoning. My phone buzzed on the counter behind me. Unknown number. I turned and looked at it, frowning, then picked it up. The text read, Mr. Abubakar Reyes. I'm a junior adjuster at Hartwell. I handled your claim initially before it was reassigned to Clifton. I have something you should know. Call me. I read it twice. Then I stood very still in the evening light of my grandmother's kitchen, the smell of old wood and plaster, and decades of cooking settling around me, and I understood that the trap was far bigger than I had measured. The junior adjuster's name was Kevin Tran. He was 26 years old, 8 months into his first real job, and he had been assigned my claim for exactly 4 days before Clifton Merrill walked into his workspace, picked up the file, and said, I'll take it from here. We spoke by phone the night before the mediation with Priya on a 3-way call, and I listened to Kevin describe the mechanics of what had happened with the particular tightness in his voice of someone carrying a weight they did not ask to pick up. He had reviewed my documentation when it first came in. He had made preliminary notes suggesting the claim appeared legitimate and straightforward. Sudden pipe failure during a documented weather event. Clear policy coverage. No indication of exclusion applicability. He had even drafted a preliminary coverage determination. Clifton had taken the file on February 5th. The same day, he wrote the email about the nuisance file in the deteriorating zip code. Kevin's preliminary notes had disappeared from the system by February 7th. Would you be willing to put that in writing? Priya asked him. Her voice was the careful kind of calm. That means she is holding something very still inside her. A pause on the line. That's why I called, Kevin said. His affidavit, notarized and submitted to the mediator by 8 o'clock on the morning of March 14th, was 4 pages. It was the most expensive 4 pages Clifton Merrill had ever generated without writing a word. The conference room was glass-walled, which I had not anticipated when Priya told me the mediation location. The building was a real estate office, occupying a ground-floor commercial space that Hartwell Premier used for community liaison meetings, their way of demonstrating neighborhood investment while systematically undervaluing neighborhood properties. On 3 sides, you could see the street, the people walking by. The neighborhood Clifton had reduced to a zip code and a pejorative adjective. I arrived 15 minutes early, which is something my grandmother taught me about rooms where outcomes are decided. Get there first. Let it become your space before anyone else's presence can define it. I sat with my back to the window and my face to the door, my single folder of documents in front of me, my hands flat on the table. Priya arrived 2 minutes after me, set her laptop on the table, and opened it without speaking. She turned it slightly so the screen was visible to the room. 3 windows. Minimized. Waiting. Clifton came in at 9 o'clock with 2 company attorneys, a senior litigator named Brandt, whose handshake communicated that he believed he was the most important person in any room he entered, and a younger associate carrying a leather portfolio that probably held the settlement number they had agreed on in the car. Clifton himself was as I remembered, silver-haired, pressed, cufflinks catching the fluorescent conference room, light the way they had caught the winter sun in his office. He surveyed the room with the efficiency of someone taking inventory of a familiar situation. He glanced at me, looked away, looked back for a fraction of a second when he registered something he could not quite name, then away again. The mediator, a retired circuit court judge named Harriet Odom, welcomed everyone, reviewed the ground rules, and invited Hartwell's counsel to begin with their position. Brandt deferred to Clifton with a small nod. Clifton spread his hands on the table in a gesture that managed to be simultaneously magnanimous and slightly theatrical, and he slid a document across toward Judge Odom. "We have revisited the file," he said, "and in the spirit of resolution, we are prepared to be generous." He let that word sit for a moment. Generous, as if it were a gift he was presenting, rather than a calculation he had made. $45,000. This is significantly above initial assessment, and we believe it represents a fair accounting of the legitimate covered losses. He glanced at me then. The full glance, not the fraction. There was condescension in it, and something that wanted to look like patience. Priya's hands moved on her keyboard. 3 clicks. The screen opened. "Before we discuss numbers," she said, in the voice she uses when she has already won and is simply managing the pace of the other side's understanding, "I would like to orient the room." The civil lawsuit was time-stamped. 8:47 that morning, filed in state court, naming Hartwell Premier Insurance and Clifton Merrill individually as defendants under the Unfair Claims Settlement Practices Act. Next to it, the State Insurance Commissioner's formal notice of investigation dated the previous week, citing Desmond's regulatory complaint and the 2 neighbor complaints as the triggering events, and filling the right third of the screen, enlarged to unmistakable clarity. "This one is a nuisance file from a deteriorating zip code. Recommend denial at first review. Claimant has submitted documentation, but property value does not support claim magnitude. Suggest we move quickly before he lawyers up." The young associate's pen stopped moving. I watched Brandt's face perform a rapid recalculation. I had seen that face before, on senior adjusters when a coverage defense they had built their case around collapsed on page 3 of the policy. It is the face of a professional understanding that the ground has shifted under them. Clifton did not move. I will give him that. He was a man who had spent 30 years maintaining composure in high-stakes rooms, and he did not flinch. But something left his face in that moment, the finish of it, the professional gloss that had been as consistent as his cufflinks. What remained underneath was something older and less managed. He looked at me, really looked this time, not the inventory glance, or the condescension glance, or the management glance, the look of a man trying to understand how he had arrived at a particular moment. "You were an adjuster," he said. His voice had lost its polish. It was almost quiet, which was somehow more unsettling than anything louder would have been. "You knew all along." I leaned forward slightly. "I knew before I walked into your office the first time," I said. "You just handed me everything I needed to prove it." Judge Odom cleared her throat with the authority of someone who has managed larger dramas than this one in smaller rooms. "Counsel, shall we proceed to the substantive matters?" Priya nodded. "We are not here to negotiate the claim amount, Mr. Merrill. We are here to give Hartwell Premier one opportunity to resolve the bad faith action before this proceeds to a jury trial." She let the phrase jury trial land and settle. "At which point, the email you are looking at on this screen, along with the affidavit from your junior adjuster describing the systematic misapplication of the gradual damage exclusion as standard practice in lower income zip codes, becomes public record in a case that will be very easy for a reporter to understand." Brandt leaned toward Clifton and said something too low for me to catch. Clifton said, "Give us 15 minutes." They were gone for 45. I drank the mediator's coffee, which was bad, and I looked out through the glass wall at Hadfield Street, moving through its morning. A woman with a stroller. Two men in hard hats, heading somewhere with purpose. A dog investigating a tree with the focused intensity of a small investigator. The neighborhood that Clifton had dismissed in a sentence. The zip code he had made his argument against. People living their lives in houses they had saved for and inherited and mortgaged and were trying to keep. Priya was reviewing something on her phone, relaxed in the manner of someone whose work is already complete and who is now simply waiting for the other side to catch up to that fact. Judge Odom was reading something on a small tablet, giving us the professional courtesy of her inattention. I thought about Kevin Tran, 26 years old, deciding on a Sunday night to text a stranger and say, "I have something you should know." About what that cost him, and what it meant that he did it anyway. I thought about Marcus Fells, on his hands and knees in my crawl space, with a moisture meter, giving the damage the serious and complete attention that Hartwell Premier had decided before the fact it did not deserve. I thought about Elena Vasquez's appraisal, $480,000, and the way that number had felt less like a victory and more like a correction of a very old record. I thought about the people who had received checks like the one Clifton sent me, $22,500, with a release buried on page 3, and had cashed them because the mortgage was due, or the car payment was overdue, or because when an insurance company sends you an official document with an official number on it, and you do not know what I know, it can feel like the end of an argument rather than the beginning of a trap. Those people existed. Many of them were in this zip code. Some of them were on this street. That thought did not produce anger, though it had at the beginning. But sitting in a glass-walled conference room, watching Clifton Merrill walk into the hallway to take the call that was going to end his career in its current form, what I felt was something closer to the emotion that produces action. The kind of feeling that turns into a plan. They came back at 10 minutes past 10. Brant sat down and placed his hands on the table in an arrangement that communicated carefully managed defeat. Clifton sat beside him and looked at the middle distance. Our client is prepared to discuss resolution of both the claim and the associated action, Brant said. We would ask that any settlement agreement include a confidentiality provision. Priya said, the regulatory investigation is a matter of public record. We will not agree to confidentiality that conflicts with or undermines that process. Within those constraints, we are open to discussing terms. It took another 2 hours. I let Priya do most of the talking because she is better at it, and because I had learned long ago that the most powerful thing you can sometimes do in a negotiation is stay quiet and let the other side feel the weight of what they are trying to get out from under. The number they eventually agreed to was $312,000. The original claim amount, $150,000. Bad faith damages under the Unfair Claims Settlement Practices Act, $87,000. Attorney's fees and costs, $75,000. Priya had ensured, in the drafting of the demand, that the settlement was structured as compensatory damages, which under IRS guidelines meant it would not be treated as taxable income. She had also insisted that the settlement agreement include no admission of liability language that would interfere with the regulatory investigation. Hartwell Premier signed at 12:34 in the afternoon. I signed at 12:35. Clifton did not look at me when it was over. He gathered his things with the careful movements of a man, being very deliberate about not showing what he was feeling, and he left the room without speaking. I watched him go. I did not feel satisfaction exactly. I felt something more specific than that, the feeling of a true thing being true. on the record, of a fact being established that would stay established. Priya and I walked out into the March afternoon together, and she put her hand on my arm and said, "Clara would be proud." I looked at her, surprised. I had not told her the house's name. "You mentioned it," she said, smiling. "In our first meeting, you told me your grandmother called it Clara." "I do not remember telling you that." "You do not always notice what you say when you are talking about that house." She squeezed my arm and let go. "Go home, Desmond." The Department of Insurance investigation concluded 3 months later with a $2.1 million regulatory fine against Hartwell Premier, the largest the agency had issued to a regional insurer in 11 years. The finding was specific: systematic misapplication of the gradual water damage exclusion as a de facto denial mechanism in zip codes identified by internal company data as lower income or transitionally gentrifying areas. Hartwell was required to conduct a mandatory review of all claims denied on that basis in the affected zip codes over the preceding 3 years. 47 claims. 19 of them resulted in retroactive payments. Clifton Morell went on administrative leave the week the fine was announced. His LinkedIn profile was quietly updated to remove his title. Kevin Tran, under whistleblower protections that Priya had ensured were explicitly named in the regulatory settlement, was transferred to Hartwell's compliance division, which was being restructured under the oversight of an independent monitor appointed by the commissioner's office. He called me once, briefly, to tell me he had been transferred. I told him he had done the right thing. He said, "I should have done it sooner." I told him that was true of most right things. I hired a contractor in April. Local company, 3 generations of the same family, which felt appropriate. They worked on Clara for 11 weeks. I was particular about what changed and what did not. The fish scale shingles stayed. The wraparound porch was rebuilt to the original specifications, with the slight leftward sag corrected this time, which my grandmother would have mixed feelings about, and which I consider a fair compromise. The original brass porch light fixture, which she had installed herself using a library book on basic wiring, was cleaned and rewired and rehung. The walls came down and went back up correctly, the pipe replaced, the mold remediated, the floors in the dining room relaid with wood that matched the original as closely as anyone in 3 states could manage. I set $80,000 aside in a property trust to cover future maintenance and taxes, because the thing my grandmother understood about property, the thing that had taken me years to understand with the same bone-deep clarity, is that owning something is not a single act. It is an ongoing commitment that requires resources, and resources require planning. Elena Vasquez appraised Clara post-renovation at $530,000. I thought about Clifton describing this house in an email he never expected anyone outside his company to read as a property from a deteriorating zip code. I thought about the 2 fingers he had used to slide my documentation back across a glass table. I kept that thought for exactly as long as it took me to appreciate it fully, and then I let it go. Holding on to it beyond its useful life would only slow me down. The community workshop was Priya's idea, though she credits me with the content. We called it "What Your Insurer Hopes You Do Not Know," which was perhaps not the most diplomatic title, but it was accurate, and accuracy has always mattered more to me than diplomacy. We ran the first session on a Thursday evening in the fellowship hall of a church 6 blocks from Clara, with 43 people in folding chairs. Priya handled the legal side, the statutory framework, the remedies available, the step-by-step process for contesting a denial. I handled what I think of as the inside knowledge, the specific language adjusters are trained to use, the phrases that are designed to manufacture uncertainty about claims that are airtight. What the words gray areas and policy limitations and good faith partial settlement actually mean when an insurance company uses them. I talked about the 4 signs of unfair claims practices, the way you explain something to someone you respect, directly, without softening the edges. Misrepresentation of policy provisions. Failure to provide a reasonable written explanation for denial. Inadequate settlement offers structured to induce waiver. Delay tactics designed to produce desperation. I watched people in those folding chairs recognize things that had happened to them. I watched the recognition move across their faces. That particular expression that is equal parts anger and relief. The feeling of finally having a language for something you knew was wrong but could not name. At the end of the first session, a woman named Doris Petaway, who had lived 4 houses down from Clara for 30 years and who had been given $14,000 for a water damage claim she had eventually accepted because she did not know she had a choice, raised her hand and asked me what she should do now. I told her to call Priya's office in the morning. Her claim was one of the 19 reopened by the regulatory review. She received $38,000 in retroactive payment. When the check arrived, she told me later, she read every page of the accompanying documentation before she signed anything. I told her my grandmother would have liked her very much. On a Saturday in late June, I stood on Clara's rebuilt porch with a cup of coffee and watched the neighborhood wake up. The morning was warm enough that the air had a particular quality I associated with childhood summers on this porch, heavy with the smell of cut grass and somebody's early cooking, 2 houses over. The deep blue paint, a color I had matched from a photograph taken in 1961, the year my grandmother first painted the exterior herself, was still new enough to be slightly bright in the sunlight, the ivory trim clean against it. By next summer, it would settle into itself, the way paint does, the way houses do. 3 doors down, Doris Petaway came out onto her own porch and looked up at the sky with her hands on her hips. A morning assessment. She saw me. She raised one hand. I raised my coffee cup. I thought about what it costs to not know what you do not know. To receive a check for $22,500 with a release buried on page 3 and believe you have reached the end of something when you are actually standing at the beginning of your own defeat. To hear the words gray areas in the voice of a man with silver cufflinks and feel uncertain about a claim that is airtight because you do not have the language for your own certainty. Those tools exist. The civil lawsuit under the Unfair Claims Settlement Practices Act, which opens the door to damages beyond your policy amount. Bad faith damages, attorney's fees, punitive damages when the willfulness is established. The regulatory complaint, which transforms a private dispute into a matter of government oversight. And public record, the public adjuster who gives the damage an independent voice that cannot be dismissed as self-interested. The careful documentation, the legal pad, the word documentation, written at the top of a fresh page before you let yourself feel anything. These tools exist. Most people in those folding chairs had not known that. Clifton Morrell had counted on that. The difference between Clifton's version of this story and the one that actually happened was 22 years of watching the inside of a machine and deciding eventually that you will not run it anymore. That it is not finally the kind of man you choose to be. That some knowledge, once you have it, becomes a form of responsibility. The brass porch light above my head caught the morning sun. My grandmother had wired it herself from a library book, which is perhaps the purest possible expression of her approach to the world. If the knowledge exists somewhere, you find it, you apply it, you do the work. The fixture was older than I was. It needed nothing from me except to be left where she had put it. Clara's porch boards were solid under my feet. The left sag was gone. The fish scale shingles were exactly as they had always been. I finished my coffee. Inside, on the kitchen table, there was a new legal pad with a new case on it, a woman in her 60s who had been offered $8,000 for a roof collapse that should have paid out $90,000, and who had found her way to our nonprofit with the documentation still in a paper bag. Priya was coming over at 11. There was work to do. But first, the morning. The neighborhood waking up around this house that had refused, through 61 years, and everything that had been thrown at it, to become anything less than what my grandmother intended. I had no intention of letting it.